That's right.
All right, sir, you want to raise your right hand? Solemnly swear or affirm to tell the whole truth and nothing but the truth to the best of your knowledge. So help you God.
Yes.
Sir, could you state your name?
Richard Michael Plank.
And could you tell the jury briefly why you haven't been in court all week?
I've been recovering from some medical stuff.
And you've had a stroke, is that true?
Yes.
And you can't sit for long periods of time?
No.
Mr. Plank, we've been hearing a lot about your company, Hawk, throughout the week. Can you tell the jurors what some of the masonry jobs Hawk did in the area were?
Strike and Bent Hill, John and Smith, Jared Jewelers, and we did a school in Gary.
So is it fair to say you've done quite a few projects throughout Northwest Indiana?
Yes, we have.
Right. Now, when you formed City Center Complex LLC, did you have to put a lot of your own money in early on to get that started?
Yes.
And did that start in 2005, spring, summer time frame?
Yep.
What were you doing? What kinds of things were you having to put your money into and get started with City Center Complex?
The dirt work, utility work, some foundation work, the permitting, the licensing, the zoning changes.
And did you have City Center zoned as mixed use, including residential?
Yes.
Is that something that you did back in 2004 even?
Yes.
And were you still then making changes to it as the project continued?
Yes.
Were changes as far as which buildings could contain residences continuing to evolve up even until December of 2005?
Yeah, we had to go again for residential. We had some residential for one building. We had to get the rest of it.
For multiple buildings?
Yes.
Okay. And was all of this ongoing before Fifth Third got involved in the project at all?
Yes, it was.
Now, some of the things you were telling us about, site work, utilities, who paid for those things?
We did.
And by we, do you mean you and your wife Joanne?
Yes.
You paid your personal funds?
Yes.
Is that for architecture designs, other early elements?
Yes, architectural. And then we paid for some utility work, some site work.
Do you have a significant amount of your own funds into this project before Fifth Third got involved at all?
Yes, I do.
All right, now, who came to you from Fifth Third with interest in this project?
Spike?
That was Brian Specht?
Yes.
Okay, we heard from Specht earlier in the week. Can you tell the jury, did you have discussions with Brian Specht about what this project was going to be?
Yes, I did.
And what kinds of things did you discuss with Brian about the project?
I discussed how it was going to be.
Your Honor, I asked what kinds of things Mr. Plank discussed with Brian Specht leading up to the bank becoming involved in the project.
I told him it was a new urbanism project, which is mixed use.
And what's new urbanism?
It's basically development with mixed use, residential, commercial.
So is that also known as a planned unit development or mixed use?
It can be called that, yes.
And had you done a lot of research into new urbanism?
Yes, I did.
Was that always your plan for this project?
Absolutely.
If you were trying to hide that this was a mixed-use project, do you think you would have put a big sign that the jurors can find if they want to reference in the white book at Exhibit 9? Do you think you would have put a big sign up that said commercial, residential, retail?
Action is leading and cause for speculation.
The question to the juror who has knowledge on this area.
What's the question? But speculative and leading.
Sir, City Center was the one that put the sign up that's referenced in Jurors Exhibit 9 in the white book, correct?
Yes, yes, it did. It's actually the real estate agent that did it.
And that was Commercial Advantage that created the sign for you?
Yes, it was. They were selling someone's face.
Was that sign prominently displayed along Broadway?
Yes, it was, right out in front.
And did that sign specifically note that residential was a component of the project?
Yes, it did.
Was City Center ever trying to hide from Fifth Third that this was going to be a residential project
No.
and that it had different aspects of retail and residential?
Yes, it did.
Did you talk to Spec about those things?
Oh, yeah.
When Spec reached out to you, did you get to know him?
I did.
Did you form a relationship with him?
Yes.
Did you trust him?
Yeah.
You did? Was there any question in your mind that Mr. Speck knew that this project was going to involve residential?
Objection. Leading to speculation, parole evidence. Motion.
Was there any question in your mind that Mr. Speck knew this project was going to involve residential? Was there any?
He knew.
He knew. Is there any question in your mind that he knew this project was going to involve Hawk's Nest being a restaurant owned and operated by you and Joanne in Building 6?
Your Honor, this witness cannot testify as to what someone else knew. That's speculative. He can't do it.
Your Honor, he's testifying about the discussions that he had with Mr. Speck and the understandings that he and Mr. Speck formed with each other.
And that violates parole evidence.
What he understands the project was going to be. Mr. Speck knew what the project was.
Okay.
To that extent, objections.
Right. Rich, was Mr. Speck receptive to your vision for city?
Yes, he was. It was the first of its kind in the area.
What was that?
It was the first of its kind in the area.
In Crown Point?
Yes.
And did you believe that he was going to represent your interest to the bank?
Yes, I did.
Objection. That calls for speculation as to what he knew Mr. Speck was going to do.
I asked what Rich believes Mr. Speck was going
His
to do.
belief is irrelevant.
I think his belief is very relevant here.
They need to get into facts, Your Honor, not hypotheticals and speculation as to what someone believed. It's self-serving in addition.
Is that what you meant with Mr. Speck for?
Okay. I can move on. Thank you. Rich, when you talked with Mr. Speck about getting involved in having Fifth Third take on the construction loan, was the first time he emailed you any documents when he sent you tentative documents about 3 days before the closing on the loan?
No.
Wasn't that the first time he sent you any documents?
Objection leading. It's been asked and answered. He said it wasn't the first time.
Rich, when did Mr. Speck send you documents? Did he send you an email about 3 days before with tentative documents?
Yes.
Okay. And were there a bunch of documents attached to that email?
There were a few.
Okay. Would 13 in fact be a few?
Yeah.
And you didn't review the documents attached to that email?
No, I didn't.
You went to the closing, then 3 days later on Friday, October 21st?
Yes, I did.
And did you go to the closing with an attorney?
No.
When you sat down at the closing, was there a big stack of documents for you to
Yes,
look
there
at?
was.
And did people flip those documents over and tell you sign here, sign here?
Yes.
And did you sign?
Sure.
Did you read those documents before you signed them?
No, I didn't.
Why didn't you read them, Rich?
Because I was told by Brian that everything...
Objection, parole evidence.
His answer
Your Honor, I'm asking why he didn't read the documents before he signed the loan documents.
because he was told by somebody something. What did he say?
I think that's what he's about to say, but that's parole evidence. That's message.
Who told? I didn't hear this back. Ken, no problem hearing.
I didn't hear this answer either. I think it was cut off, but I guess we can ask you instead, what was your understanding at the time that you were at the closing on October 21st?
Everything was covered.
Objection. First of all, we need to know what his understanding of what. The question is open-ended and broad. I don't know what she's talking about. A logical objection.
Your Honor, we've heard significant testimony throughout this case about Mr. Plank should have read the loan documents. I'm trying to ask him why he didn't read them before he signed them.
Well,
I think that's a fair
legitimate
question.
You can ask him why he didn't read it.
Can you explain to the jury why you didn't read through all of the provisions of the loan documents when you were going through this big stack of papers that you described for
I was
us?
under the impression that everything was included in it.
And was that impression formed based on all of your discussions and interactions with Mr.
Yes, it
Scott?
was. Particularly that the loan was in the credit department for so long. That I thought that credit department came up with all the language and stuff for the documents.
Did you believe that the loan was going to contain a lot of standard terms and boilerplate?
To which we will object as his belief to what it might have obtained, might have been in those documents. That's irrelevant. It's thorough evidence. That's exactly what the rules enacted.
The understanding what was in the
No, his
document.
understanding is completely irrelevant. Look at that. I need to
What was in the documents is irrelevant.
If he didn't read them, he's not alleging an ambiguity.
I think the jury's entitled to know what Mr. Plank thought going into this arrangement and upon what he formed his beliefs.
That's what we have with parallel evidence.
Overruled.
Now, okay, Rich, let's look at it this way. Maybe this won't be objectionable. You, as
I'm going
owner
to
of
strike
Hawk,
Counsel's comment as argumentative.
that's fine.
Comments stricken. Jury's disregarded comments.
Rich, as owner of Hawk, a business and masonry provider, did you engage in contracts with subcontractors on a regular basis and other people who were involved in your business?
Yes.
When you entered into a contract with a subcontractor or with another party or person, did your contracts contain all kinds of provisions in boilerplate?
No.
Your contracts contained some standard provisions, didn't they, Rick?
Yes, they did.
Okay. Now, as far as those standard provisions go, you're not very familiar with them, are you?
No.
Is it your understanding that those are in every contract that anybody would ever sign? Is it your understanding that contracts contain particular provisions that just show up in contracts because they're boilerplate?
Which was what? I think the question was all contracts everywhere between all people.
I'm talking about contracts Mr. Plank is familiar with.
Well, first of all, they have to identify what contracts.
I think she did. She said it's subcontracts, the contracts that he enters into during the course of his business.
Well, how's that relevant to the breach of the loan agreement in this case, Your Honor? That's irrelevant.
Talking about more language that's in contract. Overruled.
Mr. Plank, when you enter into agreements with other parties that you work with in your business in Hawk, if you had a problem with performance that they were providing to you, would you ever just rescind the contract without telling them what was wrong?
Objection. This is irrelevant.
I'm trying to ask Mr. Plank how he does business.
Well, that's irrelevant to this case, how he does business. It's totally irrelevant, immaterial. It's not an issue in this case, how he does business.
Overruled.
Mr. Plank, do you want me to re-ask the question?
Sure.
Okay. When you do business with other parties for Hawk, when you had Hawk before Hawk went out of business, if you had a problem with the way another party that you were contracting with was performing, would you go to them and tell them what was wrong?
Well, that calls for a hypothetical.
Yeah, we don't know.
If they had a problem, and we haven't specified what the problem is, if it was non-payment, if it was failure to provide materials, if it was failure to comply with the contract, so it calls for a hypothetical without assumed facts which aren't in evidence, in addition to my prior objection.
If there was any problem, overruled.
Would you go to them and tell them what was wrong before you just pull the rug out?
Absolutely.
Is that how you do business?
Objection irrelevant.
Overruled.
On my word and my bond. That's the way I do business.
Now, when you signed the loan documents on October 21st of 2005, did you think this city center project was going to be a good deal both for you and the bank?
Absolutely.
You were always planning to pay the bank back, weren't you?
Absolutely, sure.
You intended to be bound by that agreement and pay the bank back.
It was. They loaned me the money, I'll pay them back.
And that was predicated upon this project being built, wasn't it?
Yes, it was. Because our credit department took into account the amount of square footage.
First of all, he's responded, he's not responsive to the question. Plus, he's now speculating as to what some credit department did, that he has absolutely no knowledge of.
That's fine, Your Honor.
Go ahead.
Now, Mr. Plank, there's been a lot of talk about what you knew and didn't know when you went into this agreement. And that's why I'm asking you some of these questions. But can you tell me, when you and Mr.
Would you
Speck...
please instruct counsel not to preface her questions by explanation? That is improper. She doesn't get to explain why she's asking a particular line of questions.
I'll
She has
do
to
my
ask
best
questions to which I can object.
to answer questions
And then
in a
the
way
rest will
that would be
answer.
more acceptable to counsel. I apologize, Your Honor.
We'll see.
Let's talk a little bit about the leases. Can I just switch tracks? Is that okay? No, okay.
That's the witnesses you see for.
Thank you, Your Honor. From your discussions with Mr. Speck, did you know that the bank needed you to get leases as soon as possible for the first two buildings you were building?
Mm-hmm.
Was that your understanding with Mr. Speck?
As it was.
Did he also talk to you about LOIs?
Those were acceptable.
Okay, so according to Mr. Speck, were both leases and LOIs acceptable for the first two buildings that were going on?
Objection or evidence.
Okay.
However, can I just show a continuing objection to anything, any discussions that took place before October the 21st of 2005,
Yes.
as it pertains to the contract? That way I don't have to keep jumping him up and down.
All right.
So, as far as those first two buildings that were being built, were those buildings already being constructed, buildings number 2 and building number 6, when you signed that loan agreement on October 21st?
Yes.
You couldn't unbuild those buildings, could you?
No.
And Mr. Speck knew that, didn't he?
So it was.
Objection and calls again. How would Mr. Speck, how can he get into Mr. Speck's mind to know what he thought? How can that possibly happen?
That's fine, I'll strike it and ask it a different way. Did you show Mr. Speck the construction site?
Yes, it did.
Did he walk the site with you?
Yes.
Did he meet with you?
Yes.
Did he meet with you multiple times at City Center before you signed the loan documents?
Yes.
Now, was your understanding with Mr. Speck that you would build those buildings and get leases as soon as you could for them, for those first two buildings?
Yeah, I had to have the buildings built, otherwise you would do a lease.
It's difficult to lease a building that's not constructed at all.
That's
isn't it?
correct.
Okay. Now, did you get leases for the bottom floor of, let's look at building 2 first.
Yes. The whole bottom floor was leased.
Did you get the first lease in December of 2005 from Anytime Fitness? The first lease from Anytime Fitness? Do you recall that?
No, I don't.
You don't recall the Anytime Fitness lease?
No, not the lease. I recall Anytime Fitness, but not the lease.
Okay. What you're telling me is you don't recall the specific document,
No.
correct? When you did get the lease from Anytime Fitness, though, did you give it to Mr. Speck?
Yes.
Okay. And when you got the lease from Cold Stone Creamery in March of 2006, did you give it to Mr. Speck?
Yes, I did.
When you got the lease from Z Grill, which I believe was dated May 1st and is in the jury's white books. All three of these that I just referenced are in your white books. Did you give that to Mr. Speck as well?
Yes, I did.
Objection, approach.